Yes.
Lordship, may I be allowed to mention a matter? This is for inclusion.
Take the mic. I cannot hear you.
Lordship, may I be permitted to mention a matter for inclusion? This matter was previously listed before Justice Aniruddha Roy. There was a direction on the 1st of April 2024 to exchange affidavits. However, that has not been complied with on the part of the respondents. I've served notice on the other.
Okay.
Thank you.
Permitted to mention one matter. Inclusion, group 1 matter.
Group 1 matter inclusion with notice.
May I be permitted to mention?
You serve notice upon the respondent lawyer. I have complied with kindly.
What is it?
On side that was moved by the colleague for the petitioner. He submitted for your lordship that petitioner do not want to proceed with this case, but that is wrong. The petitioner, as soon as this fact came to knowledge of the petitioner came and filed a restoration petition and listing the matter. At that time, the court directed me to serve notice upon the previous lawyer. I have that order has already been complied, and this is a copy. I have received it. I am praying for restoration of that my original case and for listing it.
Have you filed any CAN application?
Yes, already filed. I have already filed that order on the basis of CAN application. Honorable Court directed.
Okay. List
May I
it.
be permitted to mention, Lordship?
Yes.
Lordship, I am from Jalpaiguri Circuit Bench, Lordship. One matter, FMT matter was disposed of on the last occasion I mentioned it yesterday, Lordship. My junior was not there at that time to hand over the slip, Lordship, mentioned slip. For the correction, Lordship. Actually,
Where is the sleep?
my junior is there, 60. Is there,
No.
Lordship,
No one is there to hand over the sleep.
Group 1 matter one.
Just wait. No one is there.
But so she will be coming, my lord. Actually, she's there. Actually, as I was informed, Lordship, she will be handed over, my lord. Kindly allow him.
No.
She will hand over, my lord.
Application is
Group 1 matter under application. Group 1 under application.
Lordship, on group 1 matter, I have already served the mentioning notice and it's just pending for the hearing, Your Lordship. The compensation has not been
For inclusion in the list for hearing. Okay.
May I be, Lordship, kind leave to mention on group 1 matter, extension of interim order.
Group 1.
Okay. But another matter, your Lordship was pleased to dispose of the matter long back in early 2024. When your Lordship was taking at the MECC matter. Your Lordship passed the order, thereby dismissing the appeal. Now, when I went to the register for withdraw the money, I found the name appearing in the cost title is not tallying with the name, my original name in the bank account.
Okay.
That's why I could not able to the.
Why that you have filed
application, my lord.
So you go to the appropriate bench. Why before this court?
Well, your Lordship has passed the order.
I may be passed the order. I have passed the several orders. More than 1,000 orders I have passed. Appeals.
So for appropriate order for
if
correction.
all the matter appear for such order.
But since your Lordship has passed
whether the specific bench is there, you mentioned it. File a CAN application. It can be.
I filed a CAN application because
so
since your
that can
Lordship
be disposed
passed an order.
No, I don't have the determination. You know that would be.
That's a modification or correction of the your.
Not modification.
No, not modification. But maybe correction of the
correction of the cost title of the memo of the appeal.
Yes.
So it can be done.
But I may love to the another base. If I remember, I will come to you.
Yes, you go to that.
My lord, regarding those 3 matters which were part heard, my lord, part heard and CAB, my lord, your lordship. I ought to have filed my written notes of argument within the last week, my lord. I could not, my lord. Within this Friday, I will do the same. Antaramundal Gargi Mortal, extensively hard. Yes. this Friday, my lord.
I have already taken note of that. The judgment is perhaps complete altogether, and this week, no, not this week.
Yeah, I will file it day after tomorrow, my lord. No, just your lordship, the judgments which I have relied upon, that will suffice, my lord.
Your judgments are there. You have
Just
placed
elaborating the paragraphs, my lord, at least indicating.
Very,
This is
very
my fault, my lord. That won't make much difference.
no, not your fault. Petitioners also late. They also filed the
Late, my
written
lord.
notes of argument is late.
Anyway, my lord.
Okay. You file.
Since
You
there
file.
was extensive argument, my lord, several points were
I
covered.
understand. You file.
Just your lordship will go through the same at least.
No. I'll take care of it.
Within Friday, my lord.
When you will file.
This Friday, my lord. I have completed. Just tomorrow, I will revise the same. I will file within Friday, my lord.
Within Friday.
Today is
So
Wednesday.
this week I shall not pass this order. Very well.
My lord, this month is open, my lord.
No issue.
Please.
Okay.
Lordship.
Call the list.
Item number 1. My application. It shows that this order was mentioned before the correction of the where my lord had directed that the pre-deposit amount will be paid to the opposite party. And my lord had upheld this order on January 2025. The short point for review is that firstly, my lord, we have complied with the order, but my lord, I just wanted to place one judgment which says that the pre-deposit is to be kept with the registrar and not with the opposite party.
Now, what is the direction? I think necessary to not interfere with the merit of appeal.
Yes, sir. That is the operative portion. But my lord, prior to that, towards the
Now,
beginning,
why the order is passed? Have you filed any CAN applications? No.
no, my lord, this is a review application of the order dated 3rd January.
3rd January is the order for what?
For correction of the order dated 3rd October 2024.
3rd October to the. No.
That was filed in a civil revision application.
Okay.
But we had come from the DRT where from the DRAT where the DRAT had directed us to pay 40% of the debt due.
Yes.
From that, my lord had pleased to, in revision, my lord had pleased the amount 25%.
Yes.
And given us the benefit of the amounts already deposited with the bank, which is the. My lord then subsequently on 3rd January, my lord said that no, we cannot avail of that benefit. And my lord had also said that this money must be given to the opposite party instead of the debt recovery appellate tribunal. Now, my lord, the only thing is that there are clear issues of the Supreme Court, my lord, that the pre-deposit amount must be placed before the appellate tribunal and not with the bank. My lord allows me to place one judgment on this issue.
Now, whether this review application was served?
Yes, my lord.
My lord, this is a
appeal.
excessive, malicious petitions, one after another is this filing. Reason is that, my lord, that he had taken the loan for the bank in the before 2010.
No, where is the earlier order?
Earlier order is enclosed in the review petition, my lord's order. Review petitions, huge costs to be imposed upon them, my lord. I will explain why. My lord, the order is there is a 3rd January 2025 in the review petition last order, my lord. Can you look into that? They have enclosed it. That's the last order.
What is the 3rd of October order?
I'll give my lord.
3rd of October order, my lord.
You have not annexed the order?
No, my lord, this is review of the 3rd January order.
This 3rd of October order, my lord.
My lord, this is
Firstly, they went there. Court said 50% deposit must be given. Then they filed an application before the DRT, reduced to 40%. Then surreptitiously suppressing everything, we were giving a notice, came to this court and obtained a stay order and said 25% to be deposited. Then, my lord, 25% they did not deposit. They went to the DRT court. They took time to deposit it. Then again, review petition, they are filing. Review petition. And what their condition is that before DRT passing the order, they have deposited 5 lakhs of rupees in a fixed deposit earlier. That was before filing way, that was adjusted long back. And my lord specifically says this is a matter of issue or merit. It will be decided by the DRT, the appeal. Appeal is pending there. Let the DRT decide whether 5 lakhs will get or not. But that amount was paid to me before DRT order is passed. DRT, after hearing all these things, the court directed that 19 lakhs and odd plus 12% interest is to be paid. But calculated altogether, 35 lakhs is due. And these poor depositors, it's not the bank's money, my lord. Bank is holding the money for the trust to the poor depositors. Depositor money is enjoying from 2007 and today is 2025. They are not paid the money. And they are in this court, he came three times in this court. And before the DRT, they quoted 4 or 5 times.
Yes.
So therefore, my lord, kindly impose huge cost upon them. Huge cost upon them, my lord.
I shall hear both of you, no issue.
Now, my lord, the only point is, my lord, the money that was adjusted by the bank prior to the judgment of the debt recovery tribunal, that could not have been done in the first place.
That is the issue in the merit before the learned appellate court.
But, my lord, that is also an issue pertinent to waiver.
Very well. You raise the issue before the appellate tribunal.
Yes, but my lord, with respect to the
You appear before this court in a CO.
yes,
Very limited point is
yes,
there. Your prayer was allowed.
yes,
You are given
directions
25%, 25% of the debt due.
Yes, my lord.
This is the direction.
Yes, my
So
Yeah.
what you want now?
Yeah, and directions of opposition were given, my lord. After that, when we mentioned the order for correction, because my lord, in the 3rd October order, the court had said that the pre-deposit amount would be paid to the opposite party. That is at the second last line.
A bank is not going away with the money. Anytime you get an order, you will pay the money.
That is not the point. The point is in law. In law, my lord,
What is the law? 21 proviso, my lord can look at how many times you come? Proviso, my lord, 21 proviso, my lord may go through the proviso. Where is written in the court? It deposits the court.
My lord, see
Judgment.
paragraph 23 and 24.
Every time will come something, sometimes.
Of this judgment, my lord. A clear directions of the Supreme Court on this issue, my lord.
From 2007, my lord is pending before DRT. Only a revision court, he came 3 times.
2023 judgment and decree of the DRT was in 2019, ma'am.
Filed in 2012.
2014, sir.
Yes, then 6 hours or 11 hours, 11 years.
The relevant paragraph,
You are hiding by the side of the fence, and we are ex party.
my lord, the relevant paragraphs are paragraph 21 and 23, ma'am. And my lord,
Well, 3 times you are coming here. Well, poor deposited money could not be recovered. He will allow in the bank to move a single inch.
bank is the lender. Bank is
Lenders what? Poor. Whose money? Poor depositors' money. It's not the bank's money. It's not the manager's money. It's not the money of the bank.
Paragraph 23.
21 and 23, ma'am. That is all.
Every time.
These are not legal
Yeah.
submissions. These are all emotional submissions, ma'am.
Emotional submission. What is whose money? It's the bank's money.
But in law, my lord, the money must be kept with the debt recovery.
Deposited money. Bank is holding by trust.
There can be a run on the bank can also be wound up, my lord. That is not the point. Bank is also doing.
Wound up the bank. It is the State Bank of against profit of 66,000 crores this year.
That may be, sir.
Financial chariot is moved by the State Bank of India.
Bank is a bank, my lord. Irrespective of the name.
He's a trustee. He's holding the money of the depositors. It is not the money of the bank. It's not the money of the managers.
Lord, the only other thing I will say, my lord, in revision, my lord, directions are given for an opposition to be filed. No opposition was filed.
We accepted it because we want to get the matter disposed of early. We accepted. We did not file on opposition.
Because, my lord, the court's powers in revision.
My lord, kindly impose costs of that.
Court's
For
powers.
vexatious, malicious petitions, one after another.
Paragraph 21.
My lord, see paragraph 23 first. If my lord directs me, I'll place the paragraph.
They will copy.
Sir.
And this is the first time he's submitting this. Why you are not submitted earlier?
Correct, on for date of correction.
I have not gone through this order, the judgment, my lord.
Yes.
Therefore, my lord, that amount should not have been placed with the bank, looking like the tribunals. And secondly, my lord,
Already they have deposited. Some amount is already appropriated in the bank.
my lord, the bank cannot appropriate it. That is my point. It
You have deposited 2 lakhs rupees bank.
The demand draft cannot appropriate the money, my lord. There
Why
is an
not?
entire different issue, my lord.
You have already deposited earlier. You have not raised this issue earlier.
Very hard.
And the only other thing is, my lord, with respect to the security deposits, my lord, that took place before the bank, my lord, the powers in revision of this code are vast. If there is manifest injustice, the court can go into that issue also.
That is why I'm asking to impose cost on you.
So appeal is pending now.
Appeal is pending.
Then
my
you went
Then-
well.
lord, but
Allowed no.
come in revision only because we wanted the benefit of the amounts deposited with the bank, lying with the bank at the time of sanction of the loan, which the bank is adjusted prior to taking any steps under the Debt Recovery Act or under the Securitization Act.
Amount due
Then
adjusted.
this issue, whether this issue can be decided by this court, then it will be decided by the appellate court. That is a tribunal.
Review application.
Then
But review application is purely to that.
whatever be review application or the revision,
Yes, sir.
whether this issue can be decided,
Then the
whether
court can go into the issue.
no, never be. When the appeal is pending, you approach this court in the revision regarding only how many percentage of the debt, secured debt has to be deposited.
My lord, and also with respect to the benefit of the that is-
No, that is not the issue there. I have not dealt with that issue altogether.
Yes, sir. But
Then,
one of our issues is there.
no.
And my lord, the directions were given for opposition. So the revision was not heard.
Okay, I am disposing of the CO today. I am disposing of the
CO
CO.
is already disposed of. CO is not pending.
CO is not disposed.
No, CO is disposed of only now review petition file. CO was disposed of last order.
Disposed of.
Yes, my lord. Again review.
Okay. Very good. Order dated 3rd of January.
Yes, my lord.
Very good.
Disposed of. Nothing is pending here. And my lord, category.
Okay, CO has disposed.
Yes. And DRT cannot move an inch, my lord, because I want another petition is filing here.
Okay, anything further? Okay. Please take down. Review 4 of 2025. This is an application for review of an order dated January 3rd, 2025, passed by this court in CO number 171 of 2024 against an order dated July 22nd, 2024 and order dated August 29th, 2024, passed by the learned chairman, Debt Recovery Appellate Tribunal, Calcutta 1. In IA number 236 of 2023, in connection with diary number 395 of 2023. Full stop. Learned counsel for the petitioner submits that on 3rd of January 2025, an application for correction of an order passed by this court dated 3rd of October 2024 was preferred. It was the prayer for V-Day order dated 3rd of October 2024. This court directed the petitioner to pre-deposit 25% of due debt amounting to rupees 35,40,740 with the opposite party stroke State Bank of India on or before 8th October 2024, except the amount which already deposited. Full stop. The prayer for correction was made by the petitioner only on the ground that the 25% of 25% of pre-deposit of the due date has to be deposited before the registered learned appellate tribunal, before the before the register of the appellate tribunal, instead of to the opposite party. Full stop. The prayer for correction was turned down by this court on 3rd of January 2025 on the ground that the matter can be decided by the learned appellate court. Full stop. Now, the petitioner has also filed this review application by the strength of a decision of Honorable Supreme Court passed in Axis Bank versus OBS Organics Private Limited and another, reported in within bracket 2016 12 SCC 18. Learned counsel for the petitioner referred the paragraph 21 and 23 of the decision. It is the contention of the learned counsel for the petitioner that the law declared by the Honorable Supreme Court made it clear that the pre-deposit amount has to be made with the has to be made and deposited with the learned register with the registered learned appellate tribunal instead of no, not before the opposite party stroke bank, opposite party stroke State Bank of India. Full stop. Learned counsel appearing on behalf of the State Bank of India raised strong objection and submits that the petitioner has flouted the order of this court several times and approached this court maliciously. Full stop. He further submits that by the conduct of the petitioner, the entire proceeding, that is the appeal, cannot be disposed of. It is also submission of the learned counsel for the State Bank of India that the direction of this court for depositing the money within a specific time has not met. He paid for dismissal of the instant application with a exemplary cost. Honorable Supreme Court in Axis Bank Supra has observed paragraph 20 and 23 set out call. This court, this court in disposing an application for correction on 3rd January 2025 has disposed of the revisional application being CO 171 of 2024 and directed the learned appellate tribunal to dispose of the matter as early as possible. Full stop. It appears that this court has gone through the merit of this matter regarding deposition of due date amount, deposition of percentage of due date amount at the time of filing appeal before the learned appellate tribunal. Full stop. It is the only submission of the petitioner and deliberation thereof is that the earlier amount which was deposited with the bank did not considered by the learned appellate tribunal at the time of admission of the appeal and directed the appellant to deposit 50% of the total due, which was reduced thereafter to 40%. Full stop. It is the sole contention of the petitioners that if the amount which was deposited earlier with the bank taken to be considered, the date due as appeared in the proceeding cannot be taken to be correct. However, it is the however, the merit cannot be decided in the application for review according to the provisions of Order 46, Rule 1 CPC. The arithmetical error and error apparent in the order can be corrected. The merit cannot be entertained. It appears to me that by passing order dated 3rd of January 2025, this court has of opinion, this court is of opinion that the matter can be decided by the appellate court, by the learned appellate tribunal. Thus, if the order passed by this court on 3rd of January 2025 is again considered by dint of a review application, that would be an appeal that would be determination of an appeal in disguise of review. Under the above observation, it appears to me that the application for review is not maintainable according to the provisions of Order 46, Rule 1 CPC. Under the above observation, the instant review application is considered and rejected. Review applications being review 4 of 2000 disposed of.
Obliged.
Yes. Next.
I was a little late
Yes.
submitting the mentioning slip, my lord. If the mentioning slip may be taken.
Who is mentioning?
Matter was mentioned.
It was mentioned virtually, my lord. That's why, my lord. The junior, my lord. Jalpaiguri matter, my lord, where the junior was supposed to appear in court, my lord, was not able to be there, which was mentioned for correction, my lord. Jalpaiguri matter.
Today I am taking the hearing matters. Now mentioning what?
This was mentioned, my lord, virtually, but the junior was not physically here, my lord. Just
So juniors should hear.
my lord, juniors
No,
come.
no.
Let me consider, my lord.
No indulgence. No indulgence for the juniors.
Very well.
You have to appear before on 10:30. This is not the practice of this court.
Dilam to. SB Dashgupta dilam.
Your senior is there, you are not here.
Huh.
No, this practice cannot be entertained. No, never. Yes.
Other side is there is a dead body has been.
Oh.
So those problems are only play on item number 10, extension of review order. Item 10.
Parties has to be here, otherwise how can I proceed?
File an application also.
Otherwise they can.
Tomorrow it can be as item number 1 mile to be mentioned.
Which matter?
Item 10.
Item number 10.
You'll also be called on the list.
Under the heading 2 you mentioned. Difficulties group 1 today I am not more long.
Matter is appearing in the list, but interim order yesterday also appeared.
The mention matter to be mention matter rekhe deben judge. Come on tomorrow.
Item number 1, I have another matter in court number 26. If possible, I never.
Which matter?
Item 10.
Item number 10.
My lord.
To be mention matter ta prothome rekhe. Kaলকে to be mention list ta prothome rekhe দেব। তারপরে mention matter. Okay.
I'm good. Tomorrow other matter will not be taken up today.
Let me see, call it out.
Date what?
Okay. Call the list.
5, 8, 7,
Learned friend for the other side is not here. The water remains are already there in the court.
Yes.
That is. Well, let it
Forget
be
it.
stand over for.
Okay. Next. Okay, Mr. Rawal, forget it. Let it be in the list.
Tomorrow it will.
Tomorrow it will be appear again. No issue.
But item number 4, my lord.
Yes.
But my senior friend is here, my lord. But there was a direction for affidavit, my lord. It was ready, my lord. I was seeking only maybe a 2 weeks extension, my lord. Because next week is mostly a truncated week.
Monday,
So, Monday week also এখন করতে লাগবে একটু তাই জন্য।
Tuesday.
Tuesday is a holiday.
But next week I was
Not next week.
yes, next week is a truncated week mostly.
Next week is
Monday week or Tuesday week?
22nd.
23rd maybe, my lord. 20.
So why it is pending under the mention matter?
That was the direction of the court, my lord. You also heard this matter?
Okay, I have heard this matter.
Yes. What heard matter?
Please take down item number 4.
Hmm.
Planet Council appearing on behalf of the respondent authority seeks accommodation to file affidavit in opposition. Extension of time to file affidavit in opposition. He submits that Mr. Chatterjee submits that the affidavit in opposition has already been prepared, so it can be placed within a week. Concerning the submission, the matter be urgent today. Please the matter on 23rd of April under the same head.
No.
23rd of April.
Private party আমরা add করেছি।
23
7,
10টা কালকে থাকবে তো?
obliged.
13,
Item number
Uh-huh.
13, Lordship, I beg to appear on behalf of the petition, Lordship, as the other side is near.
Call next matter.
Well, at 14, I am for the petitioner. In fact, well, all these series of matters from 14 to 18, I am appearing for the petitioners. Well, what happened?
14 to 18.
14 to 18. Well, what happened was, well, the writ petitions, apart from 14, 15 to 18, were dismissed for default. Well, we did not have knowledge. Well, finally, when we had knowledge of the dismissal, we have filed applications for recalling. Those recalling applications has been allowed and the matters have been restored. Now, my lord, in the recalling application, in opposition, the state has, my lord, come up with several documents in the opposition to the recalling, which shows, my lord, these documents were not with us. Some are subsequent and some were never with us. Now, my lord,
Whether state used the affidavit before dismissal of those matters?
yes, the direction was there, they did not file it. So the first opposition really is in the restoration application. We got some documents. Now those documents are absolutely essential to be brought on record. So we have preferred a, my lord, amendment application in item number 15 to 18.
Amendment application for what?
14 to 18, my lord, because, my lord, these facts have to be brought on record in the original writ petition, which were not available to us. It only came to light when they filed an affidavit to the restoration. But those applications are already appearing. I do not know whether my learned friends.
Item number 14, 15, 16, 17,
18. All the
Those
applications.
in all the writ petitions, there are applications for amendment.
My lord. My lord. So, my lord, I do not know
Who is
whether.
appearing for the state authority?
We have served. Service to dekha na. My lord, here are the services, my lord. Mr. Chondi Charan.
Wait. Keep it yourself. Today is not the day like that. Today is not the regular day. The models are there, so
That I
you know the
understand.
issue is otherwise. So I keep it for tomorrow.
But tomorrow I have some difficulty personally. I have to go for a visa interview at 11. So I don't want to take a chance. Can it be day after tomorrow, my lord?
11 within 11. Okay.
Day after tomorrow, my lord. I will be
Day
here.
after tomorrow, Friday.
Friday. We'll be here, my lord.
All Friday. No record for application or order. Okay.
14 to 18.
14 to 18, all Friday.
My lord. So deep.
Day after tomorrow.
My lord, one order would have helped us. One order that
So the representation of the state is required.
they are there, I believe. No. But only that we have pressed, and then because of this resolution, we will give a notice also. We will give a notice also in case, my lord.
No.
One line order.
No, not online order. Not today, at least.
My lord, not today, your lordship. My lord. We all the juniors have come, my lord. My lord. As we say, even the petrol prices would not be realized. My lord, one order from your lordship, 5 matters, my lord. One order.
Okay. No, I can pass the order, no issue, but there may be some instances.
No, my lord, there's nothing, no adverse order. Just that they will be notified, and we are not taking up this matter because of this.
Please take down. Item number 14 to 18, all each same order.
Yes.
Another order. Same order, separate orders. Give me one record at least.
Can one.
Under heading Can 1 of 2025. This is an application for amendment of read petition filed by the petitioners. Peruse the application. Let the matter be placed on day after tomorrow. That is on
11th.
11th of April 2025.
So deep.
Under the same heading for further hearing.
But so deep.
Separate order. Hmm? Call next matter.
19 in this matter, I am appearing on behalf of the petitioner. This is practically hearing matter. Exchange of affidavit has been completed. It will be placed in that under the heading hearing. Any day, my lord.
This is the motion matter.
Motion matter, that is actually bring this file, that is the previously it was hard direction for affidavit. Affidavit is completed.
Reading is complete.
Completed for this reason it will be appear as a hearing. It is the previous order is there.
Okay.
First place.
So what you want?
It
To
will be
post this matter under the heading of hearing.
Hearing, and it will be kindly taken up fixed on any day, my lord.
Who is appearing for the state?
Tapon Doctor is appearing. I
Tapon
will
Datta.
serve the notice.
Okay.
Again, I will serve the notice.
Very well. Please take down. Learned counsel appearing on behalf of the petitioner submits that this matter pleadings have completed in this matter. So the so a specific date may be fixed for hearing of this matter. Next slide. It appears that this matter appearing under the motion matter, appearing under motion matter. Full stop. As pleadings have completed, so it is necessary to post the matter under heading hearing. Let the matter be appear under the heading of hearing on April 24, 2025. Full stop. The petitioner is to serve notice upon the learned counsel for the state respondent. Next. Next.
I am appearing on behalf of the petitioner. The state respondent filed the status report without legible copy. Kindly see the status report and pass the order by the Honorable Justice Ruby Kisan Kapur on 9th July 2024. The report filed by the state is kept with records. A copy of the same is also handed over.
I submit one thing.
You are
Don't
appearing?
take me. What happened? My body has come.
Okay.
Now, one thing I am requesting. I am his chamber junior from the beginning of
Okay,
my
okay,
life.
okay. No.
I may be excuse
Are you in this matter?
matter 26. No, I don't know 26.
I am not passing any order.
My lordship kindly take it at on 15th. 15th, next Wednesday,
Item number
26.
26. Okay. You want this matter to be listed on
15th.
15th of April. 15th of April holiday.
It's 16th was any day, any.
No, 16, 17, forget about 16, come on 17.
Good.
Okay.
Good.
15 is the holiday. Very well. You go.
My lord, my humble submission, sir, kindly see the status report.
Item number 11.
अरे एक मिनट केस धरे নিয়েছি এক মিনিট করছো my lord, kindly see the status report, the annexure. No legible copy, my lord, kindly see. There is no legible copy. That is why the honorable justice
Direction was there to hand over a legible copy.
legible till that they did not file. I served a notice till that they did not serve.
Today you cannot press it. Tomorrow
Tomorrow, my lord, I will not available, my lord. Any day.
day after tomorrow.
Day after tomorrow, I will be available.
Okay. Come on day after tomorrow.
Day after tomorrow.
Today we cannot pass any order.
Yes,
You know. Okay. This matter will come, will appear day after tomorrow.
Day after tomorrow.
Very good. Day after tomorrow.
This item number 14 to 18. 14 to 18. Friday I will not be here if it can be tomorrow, but 14 to 18. I am leading them.
Okay. So they wanted to matter to be posted on Friday.
If it can be tomorrow.
Because Upavda has some difficulty. If it can be taken up at 2 p.m.
2 p.m. is it
At
possible?
2 p.m. tomorrow, I have some other determination, original side matters.
Very well. So little later in the morning,
You can say.
say around 12:30 or so if it's possible, ma'am. Because my junior will not be there.
No, the next week, that is 13 to 19, only 2 days are there.
Oh.
So
We want to make it a holiday. And I want your lordship
no,
also
I am here. I am
the
here.
lordship should also make it a holiday.
No, I am here. We
Lordship, I was
have
saying,
to. We
if
have to be
possible
there.
tomorrow, lordship, can you keep it tomorrow and then we'll take a try. We shall keep it tomorrow, ma'am.
Tomorrow. Tomorrow in this matter will appear within 10 within 11.
If it's possible, 11:30 is it possible? 11:30 or so. Well, maybe we'll take a short passover in that case. say 11.
Let it be appear. আগের অর্ডারটা করেছি না 11 করেছি হ্যাঁ তুই বলো tomorrow.
Yes, we may just seek a short passover and keep.
Okay, no issue. Great. Tomorrow. Tomorrow. Call the list.
For the respondent, today it will not be done.
It's not the good day to pass any order.
Absolutely.
You are appearing from whom?
I am for the respondent.
For the respondent. Who is for the petitioner?
Not there. So in that event,
These are the motion matters.
yes, this is a motion.
Whether pleadings or complete or report you have filed like that?
No.
So okay, let it appear tomorrow on the same heading.
Tomorrow. I am deputy.
Call the matter.
30, 31, 32, 35, 36, 38, 39.
I'm appearing for petitioner, my lord.
Petitioner. 39.
Only adjournment matter, my lord.
Very well. Tomorrow.
Kindly day after tomorrow.
Day after tomorrow.
Yes, my lord.
Okay, very well. Day after tomorrow.
Yes, my lord.
40,
My lord, in this matter, we have to file our written argument. Our argument is over, my lord. Only written notes of argument we have to file.
Whether this is Arup Day.
Yes, my lord.
Which matter?
My lord, Group 8 matter, my lord, it is wrongly appeared in the contempt application head, my lord. It
So
is,
why it is appearing in the contempt application?
I don't know, my lord, it is up to appear up to
Yes.
to be mentioned, my lord, under to be mentioned.
এটা কেন contempt এ দিয়েছেন কেন? এটা hearing
Shall I file, my lord, my written notes of argument?
নিয়ে নিন, written notes টা নিয়ে নিন, written notes টা নিয়ে নিন। This matter wrongly appeared under contempt application. The argument on behalf of the parties was concluded and the parties are given a liberty to file written notes of argument. Learned counsel appearing on behalf of the
Indian Oil Corporation.
Indian Oil Corporation Limited place the written notes of argument. Let the written notes of argument be kept in the record. Argument concluded, made CAV.
Milord, I am for the Milord IFC Shipur. It is that matter, Milord, your Lordship once again kind enough to direct my client, Milord, to send. I have submitted on 2nd, Milord. A report, Milord, column-wise, Milord, as your Lordship directed.
But today we have other difficulties in the court. You know, the body has
Only thing I am praying, Milord, let it be on record, Milord, kindly fixed on Monday, Milord, or I leave it to you one, my
you
lord.
keep it yourself. I am fixing on Monday.
Monday.
Fixing on Monday. You keep the document yourself.
My
Come on Monday. Okay.
Lordship.
Let the matter appear. Let the matter appear in the list under the same heading on Monday.
Monday.
No, Monday is the holiday.
Oh, Monday.
Monday is the holiday. 16th, Wednesday.
Then, Milord, Wednesday.
16th is Wednesday.
Wednesday, Milord.
16th. 16th.
There is some misunderstanding,
Yes.
Milord. Kindly may not take
No,
my
no issue. Mr. Mukherjee, you are here for a quite long time and practicing more than my age. So how can be there a misunderstanding?
Yes, that's Milord.
Our understanding will be misunderstanding, not yours.
No,
So don't take otherwise.
my lord.
Okay.
I'm grateful.
I have always a respect upon the senior learned counsels.
My lord.
No issue. Okay.
I'm grateful.
Next.
43, 44.
Yes, anything?
Lordship, may I humbly request that in item number 20,
20.
Lordship, I am appearing for the Indian Oil Corporation, the respondent in this matter.
Item number 20.
20, Lordship. At the time of call, Lordship, I was on the call. I was coming from the other court, Lordship, so I missed the matter. Can my appearance be recorded, Lordship?
Not today. Only not today. No order is passed today. Okay.
I'm grateful,
Come on
Lordship.
tomorrow.
I'm grateful, Lordship.
Okay.